Further hearing in the Queen on the application of B against Secretary of State for the Home Department.
Lady, my lords, we finished yesterday afternoon on the provisions in paragraph 24.
You did, Miss Harrison, but Mr. Tam got to his feet as well, which may mean he's got a little bit of housekeeping.
Yes, sorry, he has. There are some provisions relating to the issue raised by my Lord Hughes relating to police bail.
Well, may it please report that there were actually 3 items of homework which we were set last night, and we have the fruits of that, which I would ask to be handed to you now. They're coming straight away.
Thank you.
The first of these is a single sheet which is a table showing which members of this court agreed and disagreed in lumber on the Hardy-Singh provisions. I hope you forgive the slightly informal format of this, but we thought it might be useful if it's a single sheet synopsis that's easier to work with.
No, this is fine. No problem.
Thank you. And can I suggest that goes into tab 5 of the ring binder?
Yes.
The other single sheet is the chronology of Abdi, which I promised, showing the periods which were held to be lawful and unlawful. It was a little more complex than that, because there was one of the unlawful periods which was later held to be lawful by the Court of Appeal, but I've put all of that into footnotes. The one thing that I didn't manage to include in this is that in the first 4 lines of this table, where it says detained 4 times, that's actually one continuous period of detention, but it changed from lawful to unlawful, according to Mr. Justice Calvert-Smith. And similarly, in the second period, the 3 consecutive lines of detained, again, it's one period of continuous detention. And I've also footnoted for the unlawful what the reason was for unlawfulness in that first period. So it is complex, but I hope that condenses it into one easy synopsis that's easy to work with.
It's terrific. Thank you very much
And
indeed.
perhaps that can go
Does that go in tab 6?
Tab 6, please. Yep. Thank you. And then the third one, which I fear is a more substantial one, is we've printed part 4 of the case dealing with police detention. Now, I have to say, to be candid, it's not my field, and quite a lot of these provisions are both new and complex. And so I don't want to take up time making a lot of submissions about it, but can I just draw attention to the structure of section 34? So this is right at the beginning. You will see that what the statute provides, subsection 2, is a duty to release when certain events occur. And to summarise, it appears to be that what's happening there is that the person can no longer be lawfully detained. There are no more grounds for detaining the person. So there's then a duty to release. And then if you go on to subsection 5, you'll see that the release may be either without bail or on bail. It's on bail if subsection 5A applies. And so there's the specific provision there, in effect, a further investigation or proceedings. And then bail is required, release on bail is required, otherwise it's without bail. So that appears to contemplate that a person may be released on bail, even though he can no longer be detained under subsection 2. Now, that structure is also repeated, I think, in section 37 and section 41. Don't need to go through to show you that right now. Just so that my learned friend has it, the one submission that I would make on this, if I may, is simply that clearly the concept of there being bail, even though the person cannot be detained, is one which was in the contemplation of this statute. And we would say it can hardly be a surprise to find that it was in the contemplation of the 1971 Act as well.
But it's pretty express, isn't it?
Yes.
I'm absolutely precise.
Yes, it is absolutely precise. I accept that, and of course it is a different context. But the submission that all of this is a complete novelty or a complete anathema to the English law is one which we say could not be sustained in the face of this.
Thank you very much, Mr. Tam.
If I may come back to that once I've addressed my submissions as I intended to do so. The point that we reached yesterday was that the circumstances in which a person would be redetained who may or has broken their conditions of bail is predicated by reason of 241 of the schedule on the underlying power to detain, going back via para 22 and then back to the substantive power, so that it therefore comes from the underlying authority for the detention, which is in paragraph 16, Schedule 2. So that was the proposition as to the statutory construction, and we respectfully submit that the consequences, as Mr. Tam rightly accepted yesterday, that there will be inevitably circumstances in which a person who cannot be lawfully detained, such as B, who, if he breached his bail, therefore could not be recalled to prison, to detention, sorry. And that is a fundamental problem with Malone and Friends' submissions and the efficacy of its construction of the statute, which is perhaps of the most serious kind when we look at the concerns that Mr. Tam raises about impracticability on our submissions. Here we have a situation where the very purpose of bail to be released, subject to a time and place and in circumstances where you can be redetained because of potential or actual breach, does not function under his interpretation of the statute. And we respectfully submit that approach is, or our approach, is consistent with the Court of Appeal's analysis in the Stellato case. Mr. Tam's analysis is inconsistent with that approach. We looked at it briefly yesterday, but if I could just ask the Court to turn it up again. It is in volume 214, MS 1084. 14. And as was recognised yesterday, this is a case about false imprisonment. And you'll see that Mr. Kovat's submission on behalf of the Ministry of Justice set out at 859C 1087, the MS references, the grant of bail itself was authority for the detention of the person to whom it was.
I'm sorry, this is paragraph.
It's we're looking in the summary of the submission.
Yes,
which is
thanks.
859C.
Yes.
On 1087. Mr. Tam showed you the factual circumstances yesterday in terms of Mr. Stellato having the stay on the declaration that no licence conditions could be imposed upon him and the grant of bail in paragraph 8. And then again, between 13 and 14, what the issue was in the case. And again, looking at paragraph 19, the precise submission that was made by Mr. Kovacs on behalf of the Ministry. The critical finding of the Court of Appeal at paragraph 21 on 1091 B is that the only authority for Mr. Stellato's continued detention relied upon by the Ministry before the Court of Appeal was the sentence of imprisonment that had been imposed on Mr. Stellato and the legislation that was the subject of the Court's judgment. There could have been no other authority for his continued detention. So making it absolutely clear that that central proposition, which is referred to in paragraph 33 of the Court of Appeal's judgment, that bail presupposes the authority for detention, is demonstrated by this case. And we go on to see that set out in paragraph 23 and 24. And if I could ask your lordships to, and my lady, to read 23 to 24, because we respectfully submit that those paragraphs fundamentally undermine the propositions of Mr. Tam and the suggestion that bail can become disconnected from an underlying lawful authorisation for detention.
Well, the issue in Stellato, which I happen to remember,
You seem to be there, yes.
was the effect of the prison sentence, whether effectively it had come to an end or not.
Yes.
It was all to do with the commencement order and the
Yes.
early release provisions,
Yes.
which were a little bit of a tangle. But the stay was granted clearly because that issue was going to the House of Lords, or might be. and bail was attached to it. So, but the issue was in the case was the effect of the sentence of imprisonment.
Yes, and the reasoning of the court in concluding that having stayed the effect of the order pending the House of Lords judgment and the grant of bail, that did not in itself generate any lawful power to detain Mr. Stellato. It was throughout and only could be under the lawful authorisation pursuant to the legislation relating to release on conditions. And we say that fundamentally cuts across Mr. Tam's submission and fundamentally also supports the conclusions of the Court of Appeal at paragraph 33, because the circumstances here are not that the Special Immigration Appeals Commission imposed bail pending a resolution of whether or not the Hard-Elsing limits had been reached. That was decided on the 13th of February 2014. The Secretary of State did not dispute that. As we've seen from the detailed grounds of defence, the Secretary of State accepted that and confirmed that she had no longer issued any authorisation for the detention. Whether she'd done that at an earlier point, it's clear that the agreed position as set out in paragraph 23 was that the Secretary of State accepted that there could no longer be any lawful authority for the detention of B under the Immigration Acts. And so we are here in as it were, in a different situation. It's the situation once the House of Lords has endorsed the Court of Appeal's judgment, and on Mr. Tam's submission, nevertheless, there could still be the imposition of bail. We say that's fundamentally wrong and contrary to this important authority. We would also ask the court to take note, because we'll come back to it, but it's an important part of the judgment on Article 5, because ultimately it was in the context of Article 5 that the court concluded that Mr. Stellato was entitled to damages for the period of time, and that being that there having been no lawful authorisation for his detention pursuant to the criminal process and the release on parole.
But they're back to back, are they then? I mean, if it wasn't lawful, you get Article 5 quite easily, but if it was lawful, then you don't get Article 5?
Well, you wouldn't get damages for false imprisonment because there was a lawful order of the court.
Right.
And so what was left in terms of damages is does it fall nevertheless within Article 5? And the conclusion of the Court of Appeal was that it was, because you couldn't, obviously Article 5 prevents arbitrary detention. It allows for specific exceptions. And if you don't fall within any of the exceptions, then there's no power consistent with Article 5. And the only available possibility was Article 5(1)(b), pursuant to a lawful order, and the court rejected that as the only possible available option. And you'll see that the court's analysis on Article 5 is at 28.1092. And so again, we say this is a critically important judgment on the consideration of the application of Article 5(1) that would have material impact if there are cases that do arise in the future, considering the consequences of the imposition of bail in any individual case where there was no lawful authority for detention. Because on this, depending on the circumstances, of course, it would be Article 5 where the remedy may lie. Because once the underlying lawful authority for the specific purpose that's covered by Article 5, and here we have Article 5(1)(f), has gone, then there's no other basis upon which you could exercise the power to detain consistently with Article 5.
That's in relation to the fortnight during which the only basis for his detention was his breach of bail.
Yes, exactly. Yes.
Right.
Yes, that's right. So we say Stellato is an important case. My learned friend took you to it on the premise that it undermined the Court of Appeal's reliance upon the old cases of Mitcham and Armand, and we respectfully submit that that is entirely wrong. One has to look at Article 33 in the context of the findings that the court has already made in construing the statute, and in support of that took into account that the fact that habeas corpus will issue even where the person is on bail, precisely because bail does not remedy the underlying illegality that is the subject of the habeas corpus proceedings. The writ will still issue. And so, although he sought to use it as a proposition for defeating our argument as to what the common law says, and has said for a very long period of time, in our respectful submission, Stellato decided very recently reflects the underlying principle that has been a source and an understanding of the common law. Whether or not bail is an imprisonment, leave that aside. I'm not asking the court to decide that bail is an imprisonment. I'm asking the court to conclude that the Court of Appeal was correct in concluding that bail presupposes and is predicated upon a lawful authority for detention. And we say, to the extent that you get any value from the approach in habeas corpus cases, which is consistent with the analysis in Stellato, we say the Court of Appeal was correct to take it into account.
It doesn't always predicate that. If one looks at Part 4 of PACE, which we were given, you can, if the statute is express.
Yes, and actually I should have, if you look at paragraph 26 of Stellato, the Court of Appeal does recognise, sorry, I should have just taken that in that context, that this general approach may be subject to specific statutory provision.
Yes. So, I mean, if there was a specific, the whole question in the present case is whether there is, by implication,
25,
yes, but the whole question in the present case is whether there is a specific statutory exception to the general principle which you're adumbrating. Yes. And if there is, then we're outside the reasoning in Stellato on Article 5.
Well, that would be right if there is.
Yes, if there is. So but Article 5 doesn't seem to add anything, is the point I'm making.
Well, my Lord, dealing with, first of all, the question of statutory construction, there are no clear or express words.
Well, you've dealt with statutory
Yes.
construction yesterday.
Yes.
I think we must move on.
Sorry, I was seeking to answer
No,
that.
I mean, but I was putting it on a particular hypothesis.
Yes. Exactly.
Let us assume
Yes.
that there is here something analogous to Part 4 of the Bail Act, the PACE, which is the whole issue we're discussing, so let's go into its merits. If there is, then Article 5, the reasoning in Stellato on Article 5 doesn't apply, and Article 5 doesn't add anything.
Well, it may depend upon what the statutory provision does, because ultimately you would have to go back to look at the purpose. Is the statutory scheme authorising detention for the particular purpose enumerated within paragraph 5.1 A to F? And here we're concerned with the power to detain pending removal for immigration purposes. So if it were the case that the statute, contrary to our submissions, does allow for detention, for bail disconnected to the immigration purpose because there's no Hardale-Singh real prospect of removal within a reasonable period of time, then it wouldn't be under Article 5.1F.
Well, wait a minute. The immigration purpose exists for a longer period as long as there's some prospect. So the Hardale-Singh limit is simply a limit on physical detention. The immigration purpose isn't evaporated until you get to the point where there's no prospect at all. That's the whole point of Qadir.
Yes, that's the immigration purpose, but it's not the purpose of the detention power. So the detention power has to be constrained by Hardale-Singh principles.
Well, we're going around in circles. If the bail is linked to physical detention, you're obviously right. But if the bail is limited to a Qadir period, right, so long, and continues to be something which can be imposed so long as there is some prospect, then you get to a situation where there's no Article 5 objection, because that's been provided for. The whole question is whether it has been provided for. And you've made your submissions.
My Lord, yes, I've made my submissions on that.
We're not sure whether Article 5 really adds anything much to the argument, and we were contemplating asking you, so your junior can be listening hard, to sum up in one sentence what difference Article 5 makes to the argument. Supposing you lose your main argument,
yes.
What does Article 5, how does it improve your case? Don't answer me now. We'd like you to get on with the rest of your main argument.
So be it, my lady. What I was then going to finally do in terms of the statutory scheme is to show how the very same problem arises when one is concerned not with breach of bail but with surrender. That, of course, we respectfully submit is a critical part of the notion of bail. Mr. Tam suggests that the bail power is silent on its duration, and it doesn't limit the circumstances in which the existence of the bail power can operate. And we respectfully submit that that is wrong in terms of the fact that any grant of bail must be circumscribed by a direction as to its time or place into which the person is to surrender. If we go to, just go back to the statute briefly, and paragraph 22, which is 724. It's 22(1)(a) that requires for the release on a recognizance or bail bond conditioned for his appearance before an immigration officer at a time and place named, and that's the same under 2, and you get a similar provision in paragraph 29, and that is at paragraph 29(2), 752, so that bail is always going to be on the basis that it will be conditioned for his appearance, whether it's at a specified time or before the tribunal if it's been granted by the time. And that's because bail is contemplated to be on the basis that it will come to an end and the lawful authority for detention will permit the person to be taken back under into the custody of those with authority to detain. And we respectfully submit that the case of AR Pakistan makes that clear. That case is in volume 1, 2, at 601 of MS references. It's got a convoluted and somewhat bizarre set of circumstances because whilst both the Secretary of State and Mr. AR were of the view that once bail has been granted with a condition to appear before a chief immigration officer, the power to impose further bail and bail conditions was then transferred to the immigration officer, whereas the first-tier tribunal took the view that it retained exclusive jurisdiction over any change or variation to bail because it had first issued it. And the Court of Appeal rejected that analysis, but in doing so, we respectfully submit recognised again the fundamental nature and character of the grant of bail. If your lordships look at, when my lady looks at paragraph 3, you'll see what the bail conditions were, and it required, and granted by the FTT, that to appear before a chief immigration officer, and that Mr. AR did that, and when he did, the immigration officer imposed a curfew upon him and an electronic tag. You'll see that from paragraph 5, and that hadn't been ordered by the first-tier tribunal. That was the context. There was then representations and, in fact, a judicial review issued challenging the imposition of the curfew and the tag. In the consequence of that, you'll see at paragraph 7, the Secretary of State, in fact, discharged both those conditions of bail. And the issue was still determined by the upper tribunal on the basis of the proposition that I've suggested, that they were of the view that they retained jurisdiction.
Sorry, which way did they come down in the end?
The Court of Appeal concluded that that when you surrender to the immigration officer,
Yep.
the immigration officer then exercises his power to you've surrendered to custody.
Fresh grant.
It's a fresh grant, yes.
Okay.
And it can be on varied conditions. And you'll see that the ruling of the upper tribunal that was of concern in particular was 11.4, which suggested that the FTT had there were circumstances in which there was a non-finite duration in which bail could be granted. So again, engaging Mr. Tam's suggestion that there is infinite circumstances in which bail could be granted in our context, and you'll see that the court rejected that. The analysis the discussion begins at 610, paragraph 22, under the heading Duration of the FTT's Conditions of Bail. It's clear that the immigration officer who decided to revoke the conditions of bail thought that he or she was revoking conditions imposed at the time of surrender on the 15th of October. And that was in accordance with the submissions that were made by both the Secretary of State and from Mr. AR, and what was said to reflect the presidential guidance note. And that guidance note is set out below at paragraph 23. And you'll see in particular at paragraph 33, where the tribunal has granted bail, the first condition is to specify when bail will end, and then go on to set out what are the consequences. But it's contemplated that the consequence of the first condition, specifying, is when bail will end.
And from that you draw for the present question what?
And again, we respectfully submit that in circumstances where a date and time is specified at which the person is to surrender, if there's no lawful authority for their detention, that simply can't take place, because you can't surrender yourself to the custody of the immigration officer if there's no lawful authority to detain you.
So it's the same point.
It is, but it's in the context of surrender as opposed to breach of, or potential breach of bail. And if I could ask the court then just to look at the analysis of the Court of Appeal at paragraph 26.
Well, it makes the point, doesn't it?
Yes, it does. And it notes that the approach to temporary admission is of no value, and that's obviously the approach under the Kadir analysis. It recognises that the words are time-honoured words to express the idea of surrendering to bail. And then again at 27, the point that Mr. Tam makes recognises that there's no express words in paragraph 22 saying that bail conditions are to cease on surrender, but in my view, Mr. Clement's guidance correctly states the position as a matter of necessary inference from the terms of paragraph 22, in particular 22, 1A. So there is no sub-scenario of FTT bail of non-finite duration in a case where there is no pending appeal to the FTT. And so on that basis, it was concluded that the Chief Immigration Officer was both entitled to impose the curfew and the tagging, but then was also entitled to revoke it. And you'll see that at the conclusion 30, setting aside the declarations that had been made by the upper tribunal. So we submit that both those scenarios, key to the operation and the effective operation of bail, cannot function if there's no underlying authority for detention. We then go on to address further why it is, as we've submitted, that the finding of paragraph 33 about bail presupposing detention is not only made out on the proper analysis of the statute, but there is in fact a number of authorities that make precisely that point. And if I can take these as quickly as I can, the first case is the case of Conan at volume 2, tab 12. It's MS 1054, And the particular paragraph is at paragraph 30, 1065. Mr. Tam refers this into his skeleton in his written case as Mr. Justice Collins' dictum, but we say it reflects the well-known understanding as to the circumstances in which bail arises.
Paragraph.
And it's paragraph 30.
Yes.
Mr. Kovat submitted that judicial review is inappropriate since bail was an alternative remedy, and in any event it was a collateral challenge to the refusals of bail. Both his points are thoroughly bad.
Poor Mr. Kovat.
It's principled but robust in its characteristic way. We've all been on the side of that. An adjudicator is considering a bail application, is not determining. Indeed, he has no power to determine lawfulness of the detention. The grant of bail presupposes the power to detain, since a breach of a bail condition can lead to reintroduction of the detention. And Mr. Justice Collins also cited an ECHR case for that proposition under Article 5.4, Zamir in the United Kingdom. This right must be seen as independent of the possibility of applying to a court for release on bail. We say that that approach is also consistent with the way in which the Supreme Court dealt with the issue, even accepting what was said yesterday in a limited form in Lumber. And if we go to, stay in the same volume 2, tab 9, at 118, which is MS 905. And it was an acceptance at G on 9 in 108. I accept the submission of Mr. Hussain that bail is not a sufficient answer to the fundamental objection that the exclusionary rule constitutes an impermissible restriction on judicial oversight of the legality of administrative detention, then sets out the statutory provisions. And over the page at 906, bail is not a determination of the legality of detention whether at common law or for Article 5.4 purposes. And that's clearly because bail presupposes lawful detention and doesn't determine one way or the other whether it is lawful. And we...
well, those are two separate questions, with great respect.
Say that again.
Those are two separate points.
They are two separate points, but it was a point, actually, that was considered by my Lord Hughes in the Othman case, which, if we just take that up, it's at tab 6, 172, volume 6, 72, MS 2553. This was a case concerning Mr. Othman and the question of whether or not it was right for the Special Immigration Appeals Commission to have determined the Hardell Singh question. And you'll see at paragraph 18 that debate about whether SIAC ought to have done that was addressed by the court. It didn't resolve it in the end, but it did make the observation that they would share the conclusions of Mitting J and that Tam is correct. We agree first that the grant or refusal of bail is not the same as determining the legality of detention. Indeed, it assumes the power to detain. See, for example, the observation to that effect in Lumber. Then go on to see that, secondly, however, even if we were wrong to conclude that SIAC is impliedly vested with the authority to decide the Hardell Singh questions, we've not the slightest doubt that it is entitled to address them. And then goes on to make that observation, but recognise that ultimately this didn't oust the judicial review power, which could be exercised, because ultimately, that's at paragraph 21, although SIAC may make a ruling, as it did in B's case, on whether, for example, the Hardell Singh principle met, it it could not issue a mandatory order for release. All that it could do, because its just jurisdiction is limited, is to grant bail. But insofar as we take anything from paragraph 18, it is a recognition, I think based on submissions by the Secretary of State, that legality of that bail assumes the power to detain.
Well, it looks as if the author, if you're right, may have got the last but one sentence wrong, or the last but two sentences wrong. There is in this case, in a case like this, no doubt about the existence of the power to detain. The question is whether it can be exercised.
Yes, I think that, but that's the does it exist? That's the Kadir point, liable to be detained. Can it be lawfully exercised? Yes, my lord. If we then could just look at two other authorities on this vein, and I'd ask you to turn up again in volume 2, tab 6. A European Court of Human Rights case called Ismail, which concerned the question of whether bail was an Article 5.4 remedy. And in the context of a challenge to the failure to provide a speedy bail hearing. That was the particular context. But in doing so, the court set out the position as to bail as it was presented in the UK system at paragraph 12 onwards. That's at 852. 852, my lord, sorry. Paragraph 12. And cite the case of Conan that we've seen at paragraph 13 and also Lumber at 118. Then you'll see at paragraph 16 the submissions made on behalf of the United Kingdom government. Article 5, this is on 853, not applicable since the bail application was not a procedure under domestic law to challenge the lawfulness of immigration detention. They emphasise that under domestic law as interpreted by the courts, a decision to release a person on bail, subject to conditions designed to ensure his future attendance, presupposed the legality to detain. And they pointed out that the applicant had accepted that his application for bail could not and did not determine the legality of his detention, both in his skeleton argument to the Court of Appeal and in his application to the court. So to the Strasbourg court, the United Kingdom government has proffered the central proposition in this case that bail presupposes the legality to detain.
Well, there we go. These things happen.
Well, they do, but there are, but it's as a piece with the consequences of the cases that we've seen. Citing Conan, Lumber, and we would add to that the observations, albeit the point wasn't finally resolved, of my Lord Hughes in the Othman case. It was as a consequence found by the European Court of Human Rights at paragraph 28 that therefore Article 5.4 was not engaged. And you'll see that 5 lines up. The applicant chose to apply for bail on the ground that notwithstanding the detention was lawful, less coercive means such as release should be available. It follows from the fact that lawfulness of the detention under Article 5.1f is not an issue, but Article 5.4 is not engaged. And then to similar effect at paragraph 30. And then finally, one other case, which is in volume 548. Case of BB, another SIAC case, and that's at 1948, MS 1948, and the case concerned 2 questions, one about whether or not 5.4 was engaged by virtue of the statute, of the nature of the conditions, and the court concluded that it wasn't, and then a question under Article 6 and whether the grant of bail and the imposition of bail conditions engaged civil rights and obligations to which the Article 6 fair trial procedures arose, and in particular what was being sought there was of the core irreducible minimum of disclosure. That's what it's been the issue in all of these cases. And that issue is dealt with beginning at 1956. And you'll see at 32 on 1958, the summary of the claimant's case is that the SIAC bail proceedings should be regarded as detached from the deportation proceedings and as proceedings which so determine, so long as they last, the claimant's civil and human rights on the basis that his liberty was restricted. And in response to that, we have Mr. Tam's submissions at paragraph 35. And we would say this is correct to this extent, which is it was submitted below C. SIAC's bail proceedings are not freestanding. They are always, he submits, interim measures directed to deportation in the sense they are always in aid of adverse immigration action or in consideration of adverse immigration action. Referred in detail to the legislation, there may be temporary admission of a foreign national who arrives requesting leave to enter. Bail under paragraph 22 is another alternative to detention. Bail is always of an interim character to further immigration measures that are being taken or contemplated. If adverse immigration action or detention is abandoned, the power to detain and grant bail automatically ceases. And on that analysis, which we respectfully submit it is correct, the court concluded that the BB's submissions that bail was somehow freestanding and therefore attaching Article 6 protections was rejected. It was intimately linked to the deportation proceedings, and that's not a process that is, to which Article 6 applies because it's a public law matter. And you'll see that at 243, 1962 of the MS, referencing just below A.
I'm sorry, page?
Sorry, it is MS 1962.
Thank you.
Internal 243.
Yes.
And it's 3 lines down from A. SIAC bail proceedings only take place in the direct context of deportation proceedings or immigration measures. They're an alternative to a relaxation of immigration detention and are directly in aid of contemplated deportation, conditioned on a person's future attendance before an immigration officer. SIAC bail proceedings may affect a person's civil and human rights, but they do not determine them in the sense that the relevant issue at stake is the question of deportation. The bail proceedings are properly to be characterised as interim proceedings in the deportation proceedings or proceedings ancillary to the deportation proceedings.
Now, how does that help you here?
Quite.
Well, in this way, which is that in these circumstances, the decoupling of the bail power from the underlying lawful authority for detention in the first place, because there's no real prospect of removal in a reasonable period of time, means that close connection with the detention power is gone.
But the issue is so narrow, you see, Ms. Harrison. The only issue is whether, at least as far as I can see, the only issue is whether bail is permissible only up to the Hardiel-Singh buffers or up to the Kadir buffers, which come later.
You get more help.
The only issue in the case.
You get more help from Mr. Tam's, the way Mr. Tam put it, than you do from the way the court actually put it in its discussion at the end, in paragraph 39.
But the first sentence of paragraph 39 seems to endorse Mr. Tam's submission.
Yes. Well, that's true. There you are. But, I mean, people get things wrong. We've got to decide whether this is right. You've shown us some persuasive...
I think we'll get much more help out of the analysis of the statutory provisions that you took us through yesterday than we will out of any of these, which are basically about something different.
I've concluded my submission on that. And it was all to support the proposition in paragraph 33, key proposition, that bail presupposes lawful detention. And insofar as there was a submission sought to be advanced yesterday that paragraph 33 just depends upon the habeas corpus cases that were cited, then we respectfully submit that that clearly can't be the case. But that insofar as those cases do add, then they are as a piece that if you have been granted bail the underlying lawful authorisation continues, so habeas corpus would follow, and that's consistent with that approach. We would certainly seek to dissuade the court from making any endorsement of the case of U Din. That's a case about, that was the ultimate 1903 case that Mr. Tam relied upon. So A2 151095, because when he took it to you yesterday, you'll see that no authority was cited to the court for the proposition that was made, or we respectfully submit the proposition was correct, and that there is authority to the contrary. And for these purposes, if I could just give you the references rather than taking up those authorities at this time. And there's the case of Foxall and Barnett. That's authorities A13 MS 615 at paragraph 80, making it clear, again, that when you're seeking habeas corpus, what you're seeking to do is to challenge the underlying legal authorization for detention, and that will continue whether or not you've been granted bail. That case was not cited in Udin, and that insofar as the very stark proposition that underpinned the reasoning of the court in respect of what constitutes an imprisonment, which is nothing short of physical confinement, that's not the way in which the law has developed. And in particular, we've set out in our case at 94 to 103, the case of Murray, House of Lords case, endorsing an earlier case of Meering that makes it clear that whether or not something is an imprisonment is a question of fact. And that it doesn't always require physical confinement. And we respectfully submit that whatever this case is about, it's never been about whether or not the bail constituted an imprisonment. It was always about whether it requires lawful authorization, and those cases don't assist. We would also finally refer the court to the case of O'Brien, which is A7 tab 83 MS 2779 at 2785, which is more directly relevant because it concerns the circumstances in which habeas corpus would arise, and that clearly doesn't require confinement. The language that the House of Lords endorsed was restraint or confinement, and that reflects the ruling of the Court of Appeal below, which is in Supplementary Bundles tab 3 at 398, that all that was sufficient for habeas corpus to follow was de facto control. In that case, a person having been transferred to internment provisions in the Irish Free State. And so the key issue for the question of habeas corpus is, which is what was relied upon for the two cases, Mitchell and the Dutch case, was that bail doesn't address lawfulness, and so habeas corpus will still continue. We say that's as a piece the submissions that we've made. That then is our submissions in respect of the construction of the statute and that important underlying purpose, underlying proposition, the presumption of lawful authority. In terms of Mr. Tam's submissions on adopting a different approach, and the suggestion that it would be permissible to adopt a purposive approach because this is about bail and not detention, we respectfully submit that that cannot be right, because we're here construing the word detained and authority for detention. And so those well-known principles about the court's approach, which were cited by the Court of Appeal in paragraph 32, in particular the Privy Council case of Tam T. Lam, are in play. The language must be strictly interpreted, that reference is A216 MS 1097 at page 1111, judgment of Lord Brown Wilkinson. There are numerous authorities that make that same proposition, including in the context also of Article 5 and its requirements that powers to detain and to deprive of liberty must be strictly construed. And the reference for that is A number 1, so the Belmarsh case, which is at A332 MS 1230 at 1269 paragraph 36, where Lord Bingham reviewed both the domestic law authorities and the correct approach, as well as the Strasbourg case law. And we would endorse that as a summary of the position. So if it requires a strict approach and not a purposive approach, then we respectfully submit that strongly supports our submissions. In terms of the Secretary of State's other underlying rationale as to why a purposive approach should be adopted, and therefore why, in particular, one ought to adopt the approach of the Qadir latitude for...
Sorry, what's the purpose? Well, perhaps that's a question for Mr. Tam.
But the underlying purpose, was risk management.
I see, yes.
So in that context, it's management of, in our context, would be national security risk, although it doesn't directly arise on our facts because of the negligible nature of the risk. But that's the underlying rationale. And we do say in that regard that A number 1 has a lot to say about that, because although we're here concerned with bail powers and not detention, it was obviously absolutely central to the conclusion that the derogation from Article 5 in respect to foreign nationals who presented a terrorist threat but who could not be removed, and that was either temporarily or for a prolonged period, in paragraph 22 and 23 of the 2001 Act, they could not be subject to indefinite or long-term detention for the purposes of risk management alone. That was disproportionate, and it was also discriminatory, because British citizens in an analogous position, that's at paragraph 52 to 54 of the judgment, presented the same or similar risk. And we respectfully submit that there is here some analogy with that situation, because Mr. B was a person, at least temporarily, who could not be removed because of the Hardell Singh, because of the no prospects of removal. He couldn't therefore be lawfully detained, but the Secretary of State submits, nevertheless, he could be subject to severe curtailment of his liberty because of the potential national security threat. We say that's impermissible and wrong, and that it isn't the case that this is useful ground to cover, because Parliament has in fact precisely covered this ground, irremovable, whether temporarily or permanently or long-term. Foreign nationals, just like British citizens, can be subject to the legislation that was introduced to deal with the problem arising following A number 1, initially Prevention of Terrorism Act, and then subsequently TPIM legislation, which were very much less severe even than the previous control order regimes. We've included the TPIM Act. It's at A331 MS 1195. You can look at it very briefly. It abolished the Prevention of Terrorism regime under control orders, that's at 11951, and substituted it with prevention and investigative measures in 2.
Sorry, how does this help us?
It is only to illustrate that there is that the risk management problems that Malone and Friend used to justify the interpretation of the statute are in fact dealt with by a tailored specific statutory measure which is the TPIM legislation. That's the proposition that we make, and if one looks at the statute, one sees that it allows for precisely the sorts of measures that could be imposed under bail, overnight residence, etc. They are expressly provided for in the TPIM regime.
For the cases of terrorism, but not presumably for the cases of non-terrorist crime.
No, it doesn't relate to, it's only terrorism. And in that regard, and obviously that deals with the national security context, which we are concerned with here. It's in the context of criminal offenders. Again, there are schemes that deal with serious offenders in terms of release on parole, on strict license conditions, and so there is obviously already in place.
And there are various forms of prevention orders which follow conviction, and some which don't. Yes.
Yes. So Parliament has filled, to the extent that it considers necessary and appropriate, the useful ground that Mr. Tam seeks to cover by the purposive interpretation of the Immigration Act provisions. And so for that further reason, we respectfully submit that his approach should be rejected as it was by the Court of Appeal. Can I then...
You perhaps have the further point that if you're right about section 24.3, which I think is conceded,
yes,
then the purpose of using bail as a controlling mechanism is a mechanism without teeth.
Exactly, my lord, yes. I think that you can breach it with impunity. And in fact, the irony, therefore, is that if you put the person on temporary admission under paragraph 21, there is a remedy, which is that if you breached your bail, you would be subject to a prosecution under section 24 of the 1971 Act. So you can do something for the person who breaches their temporary admission. You cannot do it if they're on bail, precisely because what's recognised by the statute is that you will be returned, most likely returned to prison to detention under the authority, under the paragraph 16. So yes, my lord is entirely right. We then deal with the question of practicalities, which was my learned friend's, I think it's his fourth head of concern about the consequences of the Court of Appeal's judgment. And the first complaint that he makes is that the consequence would be that the FTT would have to determine as a jurisdictional matter whether the Hardale-Singh principles have been breached. And we respectfully submit that that is not correct, that it's quite clear that it's for the parties to put in issue jurisdiction. That's the position under the CPR Part 11, Authorities Volume 3, Tab 21, at MS 1137. And the position is also the same before the first-tier tribunal. A jurisdiction point must be taken by a party before the FTT needs to decide it and before it acts as a bar to the proceedings. And we cited two authorities in our case in respect of that. The case of Anwar, that's Authorities Volume 4, Tab 42, MS 1715, paragraphs 19 to 24. And that's MS 1723. It's a judgment of Lord Justice Sedley. A further case of Nurula, Authorities Volume 6, Tab 69, MS 2508, paragraphs 26 to 34. And in particular, we emphasise paragraph 32, which is at MS 2518. And so it isn't the case that in every single case in which the tribunal is dealing with bail, it has to consider whether it's jurisdiction. It's only if it's raised by the parties. And we did make the observation in our case that it would be unlikely that a person seeking bail would put in issue jurisdiction to grant it. Of course, consideration would be given in any case to whether or not this was a bail case or a unlawful detention case, and a choice would be made. Of course, we accept that there may be cases because there's poor representation or because it only arises on the day that an issue arises about the legality of the detention, but we respectfully submit that that does not lead to impracticability. As far as the FTT is concerned, all it can do is grant bail. And in those circumstances, if it was concerned that the person's underlying detention was unlawful, it could grant bail because it cannot rule definitively and make any mandatory or other order about the lawfulness of the detention. It could grant bail in the interim, pending an application for judicial review. That, of course, would only be necessary if the Secretary of State wished to continue to contend that the detention was lawful, i.e. not the case here, because the Secretary of State didn't dispute the conclusions of the SIAC that that the detention was now compatible with Hardell Singh principles. But if that were the case and it was a live issue between the parties, then it would be dealt with in another jurisdiction. If bail had been granted in that context, if it were then ruled that the detention were unlawful, then bail would fall away.
I was wondering if you'd ever do that, Ms. Harrison, because you'd let yourself in for the Stellato problem, wouldn't you?
Well, if it's an interim measure pending the question of whether or not there exists a lawful power to detain, which is the Stellato position, we do submit that that's permissible. We accept that if the person breached their bail, there could be a difficulty.
Then there's a real problem, yes.
But
it gets him out in the meantime, you mean? Yes, I see.
And one has to recognise, if the underlying reality is that the detention is unlawful, that's the key question. That's what the focus would need to be on, and that would need to be remedied whatever the situation, because we respectfully submit that whatever conditions of bail were imposed, they wouldn't be permissible if the detention is unlawful. But there isn't a problem of practicality. There's a need to recognise the reality of the situation if this does occur. And we do respectfully submit it's not that we've somehow attached upon some very novel proposition that will then lead to subsequent problems. The FTT is exercising and does so on a daily basis its power to grant bail on the assumption that detention is lawful. That's what it does every day. And that we are not aware of any issue that has arisen so far in that context. And so, although Mr. Tam is adept at creating potential problems, we respectfully submit that they can all be addressed, and they wouldn't in any event be a proper basis for coming to a different conclusion on the statutory scheme, which we respectfully submit is one that is ultimately in favour of the individual, because if they aren't lawfully detained, then the conditions that can be imposed upon them should be very much more limited, and only those of temporary admission. And we did pray in aid the fact that the tribunal itself is alive to these issues and has issued guidance as to how it ought to deal with this situation. It will have regard to the possibility of the detention being unlawful, but it ultimately has a limited jurisdiction circumscribed by its statutory powers. And that has guidance has been applied for some considerable period of time. The bail guidance itself is at Authorities 11-135, MS4 126, paragraphs 5:17 to 18. And certainly in the context of SIAC, the remedy that has been adopted, at least over the last 4 to 5 years, is that where there is an issue about legality, concurrent judicial review proceedings have been issued, and the president of SIAC sits both as an administrative court judge and as the chair of SIAC, and that has resulted in jurisdictional issues not preventing the appropriate remedy being granted. The other point that my learned friend relied upon was that police officers would have to decide whether or not the Hardell Singh limit was breached. We respectfully submit that that's not a proper understanding and analysis of paragraph 24(1). The police officer has to decide whether there are reasonable grounds to believe whether the person is likely to or has broken their bail. That's the question for the police officer. The question for whether or not there is an authority to detain is the one for the court. And again, that is something that we respectfully submit is appropriately addressed there. It doesn't require police officers to have to assess this question at that point. And that follows on also to what was really the primary submission below, which the Court of Appeal gave very short shrift to, and we respectfully submit properly, that Hardell Singh assessments are unsuitable for relatively junior immigration officers. And the answer to that, obviously, is that relatively junior immigration officers are deciding whether or not somebody can be detained and or continue to be detained on a regular and daily and sometimes daily basis. If they cannot apply the Hardell Singh principles, difficult though that judgment may be in an individual case, then there really is something fundamentally wrong with our system, because it does depend upon those same immigration officers making that judgment according to the rules, Rule 9, and the policy, at least on a monthly basis. When they reauthorize detention for somebody who's detained, they're having to always, policy requires them to address the Hardell Singh questions: reasonable prospect of removal, what sort of time frame, what are the factors, and they do that on a regular basis. And it's for that reason that the Court of Appeal gave those propositions a very short shrift and made reference to the fact that there is in fact very detailed guidance that assists those officers in making those judgments, and those important constitutional judgments that they need to be able to do effectively and properly. Lastly, then, there is the question of immaterial public law errors, which result in redetention to effect bail. And this is Secretary of State's case at 8.5. Clearly, an immaterial public law error wouldn't engage legality in any event. That's the ruling in Lumber, paragraph 65. It's only material errors bearing on the power to detain that render detention ultra vires and a nullity. There is there, in those circumstances, a speedy remedy, which is for a lawful exercise of the power to detain properly to be undertaken. And whilst there may be circumstances in which detention undoubtedly is lawful one day and unlawful the next day, that is a situation that is being dealt with on a regular basis. And Mr. Tam has provided you with the situation with Mr. Abdi. The management problem for the Secretary of State there is between detaining and not detaining. And that issue is addressed and dealt with effectively, operationally, on a regular basis. And so, again, it presents no fundamental problem of the kind that would warrant any different approach to the statutory scheme. Finally, then, we turn to the cases that my learned friend relied upon as somehow supporting a different approach, and I can deal with those very briefly. They were the cases that result from 2007 and 2010. Mr. Bashir's case and the ruling of Mr. Justice Mitting that having concluded that he was unlawfully detained, imposed a 12-hour curfew and bail, it's conceded and accepted by the Secretary of State that in all of those cases there was no legal argument. It was either done at the volition of the judge, Mr. Justice Mitting, in a number of the cases, and either with concession by counsel or no argument. And so they really don't take the matter further. We'd only make the observation that even in that context, issues were raised about whether or not that was the correct approach. Certainly in one of the cases, the case of D, Miss Weston raised an issue of principle as to whether or not it would be appropriate to grant bail or temporary admission. And when one, and also in the case of Ahmed, which is Authorities Volume 38, MS 1490, at MS 1505, Mr. Justice Langstaff did recognise that there could be some important point of principle, but there was a concession between the parties. So it wasn't as if it was all done without some issue at least being raised. And the other observation that we make is that certainly from the reading of the conditions that were imposed in cases like Ahmed, Hussein and HY, they were conditions that could be imposed under temporary admission. And so it's not that there wasn't a means to address the concerns. That they were conditions that didn't include curfews. So for those reasons, we'd ask you to place no weight at all on what's called the Bashir line of authority. That leaves me then with the question of Article 5. I'm grateful to Mr. Vaughan. I'll have to read this.
Got the sentence now.
I don't know if it's right.
Well, just remind us where we find Article 5. You showed us a moment ago, rather usefully, set out in some authority.
It was set out in Stellato.
Ah, yes. That's right. Yes.
And in the authorities, it's Volume 3, Tab 24, at page 20.
That was helpful. Thank you.
We rely upon Article 5 in particular, and in addition to what we have submitted under the domestic provisions for the Stellato point, which is that it demonstrates quite clearly that there would be no power at all under Article 5 to re-detain somebody who had either breached bail or had failed to surrender, but in particular breached bail. And that obviously has most direct bearing in circumstances where the grant of bail is by a court, because that's the circumstances with Mr. Stellato, and where it was accepted that he didn't have a false imprisonment claim, and his damages therefore are exclusively under Article 5.5.
We can do that, yes.
Yes, so in terms of practicality, is there anything that you gain from it practically for how in the future we may have to resolve these issues? That's the primary additional aspect that Article 5 provides. It also obviously provides a more robust interpretive obligation in Section 3, even more so than the legality principle, which we obviously have evoked in Sims and Pearson. If there was something in Mr. Tam's construction...
It takes you back to the statutory construction point.
Yes, it does. It goes back to that. If the court were at all persuaded by anything from the terms of the language of the statute to supporting his proposition, we would respectfully submit that Article 3 would give us that additional, more intrusive interpretative obligation. than under the common law, powerful though that is. We also respectfully submit that the Article 5.4 aspect of the case is important, because what it makes clear from cases like Ismail and other cases is that bail would not be an adequate remedy for 5.4 purposes in circumstances where the person cannot be lawfully detained. We say that's a critically important dimension to the legal framework. And ultimately, that is why we say Article 5.4 does add to the substance of the arguments. We would accept and indeed submit that as far as the analysis under Article 5.1 is concerned, then the common law and Article 5 are ad idem on this issue. They all apply the same approaches. They apply, although it's under a different concept of arbitrariness and or proportionality, the Hardell-Singh principles, and they would have the same result. It's only in those two contexts about redetention and 5.4 that we say there's something additional to add to the dimension, which may have consequences in the future, at least for claims for false imprisonment and or damages. Those are all my submissions, unless there are any further questions from the court.
I think we've asked you all the questions we wanted to ask you. Thank you very much, Ms. Harrison. Thank you.
Yes, of course.
Mr. Vaughan? Thank you. Thank you for your sentence, Mr. Vaughan. It was a bit more than a sentence.
Sorry.
My lady,
not much more.
Ultimately, this case is about the analysis of statutory provisions. There are two statutes, though, not one, because the Human Rights Act is relevant, but I'll put that to one side for now. Analysing the 1971 Act, the first key reference point is the phrase detained under. In paragraph 22 of the schedule, it's page 724, and the Act is in Authorities 1 at tab 4. Detained under paragraph so-and-so. Secretary of State says purportedly, lawfully or unlawfully. So let's test it. Take a person who cannot lawfully be in immigration detention. And it's not just Hardell-Singh. They might be a person for whom it would be a breach of published detention policy. That's lumbar. To be in immigration detention from day one. Or it could be a Hardell-Singh case, and we give these examples in our printed case, paragraphs 15 and 17, page 179, 180. Hardell-Singh example, I'm serving a prison sentence. I'm approaching the end of the custodial term, but I am at the Hardell-Singh limits, not the Kadir limits, the Hardell-Singh limits, because it's already apparent, Lord Dyson's word, that the Secretary of State wouldn't be able to effect a deportation within a reasonable period. Even if I'm an abscond risk, even if I'm a national security risk. And take those examples, and the Secretary of State writes me a letter, I'm intending to detain you, I can get to the court for a declaration, my immigration detention would be unlawful. Secretary of State's position is this: if the immigration officials do their job and never detain me, I can never be on bail under these provisions. If they don't do their job and detain me unlawfully, I can forever be on immigration bail under these provisions until the Kadir long stop. It is very striking for the same person there should be such different consequences depending on an act, and an act that is unlawful. Moreover, if it were purported, why doesn't it bring in Kadir? I detain you. Anyone can be purportedly detained under immigration powers. There's no deportation order which is needed. There's no recommendation of a court which is needed. But I purport to detain you under immigration powers. Someone who's at the Kadir long stop could be purportedly detained under immigration powers. And yet the Secretary of State accepts there couldn't be bail in those circumstances. Which illustrates immediately she's reading in something else. She's reading in liable to detention as well as purported. It also illustrates that every time Mr. Tam says there's a problem with having to consider a limit, she's got that on her own case, because you always have to consider the Kadir point, including any niceties of the jurisdiction of the tribunal on a bail application if you had a Kadir limit case. If Parliament were, as Mr. Tam put it, providing bail to get people out when detention is unlawful, or as he also put it, as a sensible power when the Hardy-Singh limits have been reached, bail would be an Article 5.4 jurisdiction, which it isn't and never has been. Zamir in 1985, page 308, volume 10, tab 113, our paragraph 34, at page 188, Zamir 109, 3808. And the Hardy-Singh cases were always habeas cases. Hardy-Singh itself, Tante Lam, I, and so on and so forth. That's our paragraph 27 on page 185. I'm not going back on the Conan line, but Ismail is very clearly talking about the exercise of the power, not the existence, in those paragraphs that you saw in Ismail, pages 852, 853, 856, volume 2, at tab 6. Othman, which you saw at 2553, page 2553, volume 6, tab 72, answers the question, what should the tribunal do? Because it says, inevitably, it's going to look at the question. And it answers the point about parallel judicial review or habeas corpus, because it recognises that that can indeed be the position. The correct analysis in law, when the case comes before the tribunal, is that if there is no power, the exercise of the power to detain would be unlawful in law. The position is the Secretary of State must release at that point. Yes, temporary admission is available. That's the answer in law. It's no different when one's got a bail tribunal as it might be if you've got the parole board and a licence case and a question of recall and a Mr. Stellato, who in fact shouldn't be on licence. He's entitled to unconditional release because of a convoluted set of statutory provisions. But as I've said, Mr. Tam's own case is that the Kadir long stop can arise before a bail tribunal. So this set of issues, what do you do, given that you haven't got a 5.4 jurisdiction, given that you can't rule on legality, and given that you can only release on bail? Now, it's all in our paragraph 25, at page 184 and 185 of the bundle, because we've set out there what the guidance says about this. It's entirely workable, and it's nothing new or novel. So that's reference point number one. You're detained under a power when you're lawfully detained under a power. Liable to detention, which she also needs, the Secretary of State has to read that in. That's where she gets to her Kadir long stop. Well, the points are obvious, you've got them. It doesn't say liable to detention in paragraph 22. It would be easy to say liable to detention in paragraph 22 if that's what Parliament meant, particularly given that it did open paragraph 21, which is the preceding paragraph of the same to the same statute, with precisely those words on the previous page, on 723. Moreover, the Secretary of State's three layers of control, detention is one, bail conditions is another, temporary admission conditions is the third. Those three layers work if Ms. Harrison is right and the Court of Appeal is right. But Mr. Tam collapses them because he says the bail layer and the temporary admission layer are controlled by the same feature namely liable to detention. We can add this point, my lady, my lords. If Mr. Tam is right in his interpretation of detained under in paragraph 22 on page 724, if he's right about that, that incorporates liable to detention as an ongoing control. Where does that leave paragraph 21? Because the phrase that won the day for the Secretary of State in Qadir, person liable to detention, is now on this argument redundant in OTOs, because if you deleted those words, she would still have won by a person detained under.
Well, she might in that case, but in others where someone is not yet physically in custody, you would need liable to detention.
Correct, but what is very clear from Qadir is that the race, why she wins is because of the phrase liable to detention.
Yeah, I've got that.
She needed it there, but her argument in this case ends up with, now I could do it anyway, by reference to the other language. So those are the linguistic points, and you've got those, I know. Next reference point, on the same page in 22, is the phrase, on his entering. In 22(1)(a), immigration officer may release a person so detained on his entering into a recognizance condition for his appearance. And then you read that with 22(2), which is the recognizance condition can include other conditions. And those are where the bail conditions come in. And just to comfort you, the wording that is now in 22(1)(a) was always in the 1971.
Oh, thank you, yes, I was wondering about that.
Originally in 22(1). I wanted to check that, lest you thought that this had come in 1996.
Just slightly bothered, yes.
So what you've got is this. Parliament sets out a universally applicable conditional release mechanism in 22(1)(a), where you are released on doing something. You have to accept something. You have to say, yes, I will enter into this recognizance and accept these conditions. Now, think back to Mr. Stellato, who took a very principled position. He would not cooperate because his position was, I'm entitled to be released unconditionally. It's paragraph 4 of Stellato at page 1088. That's what led to those issues. So imagine a Mr. Stellato. I can't be detained lawfully in immigration detention, whether it's the published detention policy, whether it's the Hardy or Singh limits or some other basis. You are saying you will release me, but only if I will accept certain things, including conditions that you decide to impose that are covered by subparagraph 2 of 22. Now, the general structure of this, we say, is unmistakable. Bail is presupposing a lawful, present, and ongoing detainability as the exercise of the power against the individual. And in Hardy or Singh terms, the Secretary of State has just one answer to this point, which is that the abscond risk may change if there is non-cooperation, which may recalibrate Hardy or Singh in a particular case, and which could then render the detention lawful. And you had a discussion about that yesterday. But one example, and we accept at our paragraph 36 of our printed case at page 189, you could have an example where there could be a change in the analysis in relation to Article 6. That can't carry the day when you are construing a statutory scheme which is imposing a universally applicable conditional release mechanism, which is premised. It only works, it only has teeth, because you can detain me tomorrow if I won't accept this. And if you can detain me tomorrow because I won't accept this, Parliament clearly has in mind that I can lawfully be detained tomorrow under the immigration detention powers, because the powers haven't changed. It's still the immigration power, detention, detained under paragraph 16, detained under paragraph 16.2, and so on and so forth. Now, the statute, there's no lacuna in the statute for the example I've just given of the non-cooperative Mr. Stellato, because temporary admission specifically allows reporting controls, and I'll come to that. And there's a criminal sanction attached to that. So that's reference point number 2. Reference point number 3, my lady, my lords. The phrase, his appearance before, in the same provision, 22.1a. And you've seen the authority, the way this works. But what happens next? Let's assume I do accept it, and I am released on bail. I then appear. When I appear, my bail stops. My status is I am detained, and that is the structure of the statute. That's how it operates in every case. That only works on the premise of a lawful power to detain me that continues. It's not just the trigger at the moment of initial release. And reference point number, I think I'm on to 4, is the phrase, may instead of taking the bail, in paragraph 22.3 on page 725. In any case in which an immigration officer or tribunal has power under this paragraph to release a person on bail, the officer may, instead of taking the bail, fix the amount and conditions with a view to its being taken subsequently, and on to being taken subsequently, the person shall be released. That is a generally applicable deferral power. Yes. In every case. The immigration officer can say, I'm not going to release you on bail, I'm going to defer it, I'll set some conditions, your release will be at a later date. The point is the same theme. It reinforces Ms. Harrison's point that it necessarily presupposes, that there is a detention power, detention of the individual will be lawful, present, and ongoing. Not existence, but exercise. And that's not a function of risk changing. Mr. Tam's example wouldn't bite there at all. That's not going to be a change of circumstances that could affect Hardy or Singh. And it is explicit in every case. Next reference point, I think we're on to number 5, of the opinion in paragraph 24.3 at the bottom of 727. Of the opinion that has broken or is likely to break a condition. And then 24.3b, if not of that opinion, shall release. Same point. It's a generally applicable on the structure of the statute, re-triggering of detention, where I've broken a condition or I'm assessed as likely to break a condition, and if you're not of that opinion, then I get released. That's the on a string point that we had yesterday morning. We deal with that at paragraph 23, page 183. But for the one swallow doesn't make a summer point, which is that there could be a case in which Hardy or Singh limits get recalibrated if you've breached, which I accept. But that's not an answer when we are construing an act whose structure is clear and is clear as these are all generally applicable provisions. Then back to paragraph 21, just to make good on the point about no lacuna. Such restrictions, if we take that phrase in paragraph 21, subparagraph 2 on page 723. My lady, my lords, I hope I have that 723. I know you've seen these. Such restrictions as to reporting to an immigration officer as may from time to time be notified by him, to him, in writing by the immigration officer. So Parliament has expressly provided that if you are released on temporary admission, you are under reporting restriction controls, and it can also be on restrictions as to residence. Not only that, Parliament, recognising Article 5, provides that the breach of that is a crime. That's section 24(1)(e) on page 641, 642, which you have seen. Applies to TA. You're not detainable, but you breach a condition and you can be arrested on suspicion of a crime. In other words, under the other limbs, 5(1)(c) of Article 5. In prison for up to 6 months, and if there is a change of circumstances that recalibrate hardy or sin, because now the reasonable time is different. It was 6 months if you were a compliant individual, it's 12 months if you are a non-compliant individual. Secretary of State has authority to detain because the circumstances have changed, and the detention at that point would be lawful detention. But the structure of the Act is that the string that I'm on is I can be re-detained if I break a condition. I can be re-detained if I'm likely to break a condition. And that's the very basis on which my bail operates in circumstances where I had to agree to the conditions in order to get release in the first place. That's all I want to say about the 1971 Act. Does the Human Rights Act make a difference? Answer, yes. It's not necessary in this case because Lord Dyson, Lady Justice Black, as she was at the time, and Lord Justice Richards are right, and it decides this case. But you can see what's coming, and was missing from Mr. Tam's list in relation to the new statute provision, because what's coming is Article 5. But let me explain, let me not argue another case, let me argue this case. How does Article 5 relate to the analysis that you've heard and I've just given to you? The key point is that the Hardy-Singh limits are also the Article 5(1)(f) limits. I'll show you it. I'll show you it in a moment in the authorities. We've set it all out in our case. Not only that, the lumbar basis for unlawful detention is also an Article 5 limit, because the point about having and adhering to a published policy is that you are acting in accordance with the law in Article 5 terms. I'll try it in a sentence, but the premise then is that, let's assume that the statutory provisions as a matter of your interpretation of the domestic statute say that these powers are applicable even where the Hardy-Singh limits have been reached. Assume that is a section in the statute. The submission is that all of the provisions that are the structure of bail, the maintenance of detention if the individual doesn't accept the conditions, 22(1)(a), the deferral of bail, 22(3), the surrender to your bail, the re-detention if you breach or are likely to breach, including the arrest in paragraph 24, would all be incompatible in a case where you are at the Hardy-Singh limits, subject only to the example where the risk analysis changes. They would all be incompatible. And they would all be incompatible because if I am a person who is at that Hardy-Singh limit, taking into account abscond risk and everything else, I cannot lawfully be detained. I am entitled to decline those conditions and that recognizance because you can't hold me, because I'm at the limits of Article 5 immigration detention. And this is 5(1)(f). It's not something else. Whatever's the position with police bail, nor can you defer my bail under 22(3). nor can you re-detain me when I surrender to bail, nor can you arrest me under 24 or re-detain me under 24, because all of those would be immigration detention, which would breach Article 5, because 5.1f limits are Hardy-Singh limits. And if I'm entitled to decline, like Mr. Stellato, to accept conditions because I'm entitled to be released, you can't hold me, I'm at my Hardy-Singh and Article 5 limits, it follows that bail is unlawful. Not just the structure of the statute goes, and there are declarations of incompatibility everywhere, but the bail is unlawful, because the bail will let you out if you accept conditions. But once I'm at the limits of Article 5, I can't be held. And you can't hold me tomorrow or in a week's time. Now, there's no problem with temporary admission and arrest for breaching a condition. I've explained that's 5.1c, because it's a crime. And there's no problem with change of circumstances, if there is such a case, because that will be lawful under 5.1f. But structurally, this Act does not work alongside the Act that Parliament enacted in 1998, the Human Rights Act. Unless Ms. Harrison is right, and if there were a clash, if it were less clear, and even if you couldn't get there via Section 3, then you've got a declaration of incompatibility. But does Article 5 affect the analysis? Yes, it does. And I need to just make good on the fact that the 5.1f limits are the Hardy-Singh limits. And the authority is JN at 3510 in Volume 9, Tab 102. This is the shortcut. There's a longer way of doing it. But Volume 9, Tab 102, page 3510, you'll see Strasbourg saying at 3510 at the end of paragraph 97, having set out the Hardy-Singh principles, end of 97 on page 3510, the test applied by the United Kingdom courts is therefore almost identical to that applied by this court under 5.1f in determining whether or not detention has become arbitrary. Bottom of the page, a test similar to, indeed modelled on, Lord Hoffman would approve. The Convention didn't come into the Human Rights Act till 1998, but the British were always involved in it. And immigration detention and what Mr. Justice Wolfers made of it in Hardy-Singh all reflects the two limbs of 5.1f. Detention on entry, detention for the purposes of removal. The authorities we gave you in our printed case, if you look at some stage at our paragraphs 39 to 42, at the end of each paragraph, what we do is we set out each Hardy-Singh principle, and for each one we give you Strasbourg authority and a quote that shows you that the same principle that is seen domestically in Hardy-Singh is reflected in the judgments of the Strasbourg court. 39 is at 191, so it's Chahal, and that is page 3406 in volume 9, tab 99, end of R39. Sardi is volume 10, tab 110, it's page 3744. Mikolenko is at the end of paragraph 41, page 3660 in tab 107 of volume 10, and Chahal is the same reference as for Hardy-Singh 1, page 3406, tab 99 of volume 9. So each Hardy-Singh principle is reflected in what the Strasbourg court recognises are the limits of Article 5.1f detention. The lumber point about arbitrariness is paragraphs 32 to 34 in Lumber, page 885 to 886, volume 2, tab 9. That's where Lord Dyson in Lumber is explaining the whole point of having a policy and adhering to it is to meet the Strasbourg requirement that detention has to be lawful. So in my other example, and I make no bones about it, I would say any unlawfulness of detention, any case in which the detention power cannot lawfully be exercised against the individual will violate Article 5.1, because lawful means domestically lawful. But the Lumber example is given there, and there's a nice paragraph at 34 about the rule of law. The rule of law requires that you have policies and that you adhere to them, and that's why the detention's unlawful in Lumber. You've had a policy and you breach it, and that violates Article 5. So if you can't have declining to release the individual, if you can't have deferring, if you can't have surrendering to their bail, and if you can't have redetention, because you're already at the limits of Article 5, this statutory scheme simply does not work compatibly with Article 5, and I am entitled with Mr. Stellato to say no. I have an unconditional entitlement subject to your other powers, temporary admission or your non-discriminatory powers and TPIMs, etc. Now, the only way out would be to try and get this under 5.1b. We have dealt with that in our printed case at paragraph 35. The Secretary of State in her case makes very clear that she accepts that this, the relevant power of detention throughout, including all the way up to redetention, is 5.1f. She's right about that. This won't fit with 5.1b, concrete obligation unfulfilled by the individual, where detention secures its fulfilment, and you release me as soon as I have fulfilled that concrete obligation. And we've given you the authorities. It's all in our paragraph 35 at page 188 to 189. The 1984 Act and police bail, I don't know if you've heard enough, but since that was raised this morning, can I have a minute on that?
You've got 2 minutes left,
Oh, good.
Mr. Fordham.
I forgot to say that.
That's not 5.1f at all. 5.3, Article 5.3 makes clear that you can have release on conditions that secure your attendance. It's the end of Article 5.3. For the issue that we've got to arise under the police bail statute, you'd have to have a situation where the detention could no longer be lawful under Article 5, because the statute's clear, we've seen that. So it's no longer available under Article 5, an equivalent of Hardy or Singh limits. And nevertheless, the statute is saying you can maintain the detention, you can defer the grant of bail, you can require the surrender to bail, you can re-detain. It's not clear at all that that issue arises on that statutory scheme. But if it did, I unhesitatingly submit that it wouldn't be compatible. It couldn't be. If any of those things were a feature of the legislation and you had a breach of Article 5, but we wouldn't be under 1F, we'd be doing a different analysis of different principles. In fact, that statute, we say, is an example of the point that my Lord Mance teased out yesterday about you have to put bail to one side when you are looking at would the exercise of the power be lawful. And this is a statute where the entitlement to release on bail and the you can't detain are two sides of the same coin. That's the structure that Parliament has set out. You can't detain this person any longer. They are entitled to be released on bail. But as we saw yesterday, you have to look at would it be lawful to detain, leaving aside the bail. No, there's no difficulty with Kambadzi. It folds into the analysis in exactly the same way. If there isn't authorised detention at the beginning, you haven't got lawful detention, and purported won't do. But I accept that you don't have to keep having authority to detain someone while they are on bail. That's never been the submission. The question is, would the exercise of the detention power be lawful today in their case? And finally, there's no problem with the Stellato grant of bail having made the finding, because it's the finding that was stayed at paragraph 7 of Stellato, and you were very careful with respect to stay the conclusion of unlawfulness before you then gave bail. So it's a nice try, but it doesn't work. It's on that basis, that was the legal logic on which the court in that case had granted bail. You may have heard gasps behind me when the Secretary of State told you that immigration detention is used rarely. The United Kingdom has the dubious distinction of being a world leader when it comes to immigration detention. We'd like to thank you for allowing us to intervene by being here, and I would publicly like to thank Allen and Overy for the work that they have done yet again pro bono in this intervention. Unless there are any questions for me, those are our submissions on the intervention.
No, thank you very much, Mr. Fordham, and thank you for appearing pro bono too, and John Leonard Jr. Mr. Tam.
May I please the court? May I just have a moment?
Mr. Tam, we proposed to rise at 20 to 1. I said 1:45, but I'm saying 22 because then that will give the one of us who's got another engagement to go to plenty of time so to do. So don't feel under any pressure to finish by then. We are perfectly happy to resume after the longer short adjournment so that you've got plenty of time to finish your submissions.
I'm grateful for that, but in fact, my lady, I think I can probably finish by 20 to 1, so let me give that a try. The court has our printed case, and one thing I'm conscious of is that I shouldn't just repeat things I've already said. Hence, I'll confine the reply simply to points that have arisen from the following from the argument from friends. Can I deal in part with questions that we've had to work on, as well as proper legal reply points? Learned friend Ms. Harrison made some submissions about the provisions of paragraph 17 and following in Schedule 2. I think I do need to ask you to turn this up. It's Authorities 1, tab 4. And this will start at MS 718. You'll remember 16 on the previous page is a detention power, and then 17 has a power of arrest for anybody who's liable to be detained under paragraph 16. I think learned friend may have said that she thought it was very rarely used. In fact, what we've been told is that this power is probably accounts for nearly all of the arrests made by immigration enforcement, because this is the power of arrest that's used when people have to be, if I can put it colloquially, picked up for some reason, or there's an operation perhaps on business premises and people are found there who shouldn't be here or shouldn't be working.
Well, that's what I thought. That's
yes,
why I made the comment I did.
That's right. And so it is actually a very commonly used power. We, of course, accept that once the person's been arrested, then the Hardy-Singh principles will apply. And the same, for that matter, applies for those who have been arrested for a breach of bail and brought before the tribunal. And the tribunal then has to itself consider whether to order or direct further detention or to release on bail. And if further detention is directed, then the Hardy-Singh principles will still apply. The balance may change, of course, because of what's happened, and I've made that submission already, but we do accept that the principles still apply. Can I then return to these provisions? 17, 18, 18A and 18B are all provisions about individuals who have actually lost their liberty. They have actually been arrested, and they are then detained. In respect of those, we accept that the principle of construing these strictly is one that is relevant. The difference is, we say, that when you come to paragraph 22, the bail power. The bail power is not about somebody who's going to continue to be detained. They're going to be released. And that is something that makes all the difference. The next group of points comes from learned friend submissions that our case somehow disconnects bail from the powers and the purposes of the immigration statute. We say that's not so. First of all, there's no disconnect from the power to detain, because we accept that the bail power will only last so long as the power to detain continues to exist, that is to say, up to the Qadir endpoint. And so that connection is always in place. And it is always possible that the power to detain can be lawfully exercised at some point, even if it is perhaps right at the end for the purposes of removal. And that is why that makes sense and there's no disconnection there. The other point is that there's no disconnection from the purposes of the immigration system. Learned friends sought to suggest that somehow using bail as a method of risk reduction disconnected it from immigration. That is not right, because both bail and restrictions on temporary admission are measures that will reduce risk. That's why they're there. And Qadir recognised that that is available where temporary admission is concerned, and so too must risk reduction be available in respect of bail. So there's no disconnection from the immigration purposes. Of course, I accept there are other measures which may, in certain circumstances, come into play. At one extreme, control orders, TPIMs now, as my learned friend says, and in the criminal field, there may be other measures. But even where serious criminals are concerned, a licence may have expired, and the person may not be under any further restrictions there. The crime may not be one in respect of which a prevention order is appropriate. And so the immigration system, given that its purpose includes making this country safer from criminals who should not be here, can legitimately include in it measures that will reduce those risks pending the departure of the individual. If you need authority for that, it's in Lumber. That's authorities to tab 9 at paragraphs 107 to 109, MS 903. That's in the section talking about the relevance of the risk of offending, or risk of reoffending. If you can detain to protect against reoffending, you must be able to have bail conditions that protect against that risk without detaining the individual. It's also said against me that it's a consequence of our case that the bail power would be available even if there's no detention authority at all. We respectfully say that that cannot be right. First of all, at the point of release, the individual must be detained under paragraph 16, or whichever is the corresponding power. That is what the statute provides. So we say that there is a limitation there. The difference between the parties is whether that power is available even where the detention is unlawful. So it's not the case that the bail power exists even where there's no detention authority at all. Thereafter, and this highlights the difference between the initial point and the continuance of the bail power about which the statute is silent, thereafter there cannot be a continuing authority for detention because the person is bailed. He's not in detention anymore, and there is no further authority. And so that is not a point which avails learned friend in this case. Can I then say a brief word about the case of Stellato? The part of the Stellato chronology that is relevant to our case is that part when he was granted bail and he was released on bail. It may only have been a short period because of his attitude to it. but the Court of Appeal had found an underlying absence of authority to detain, and yet the grant of bail was considered by the Court of Appeal to be a useful and appropriate tool in the circumstances. I don't seek to. We cited Stellato as the demonstration that bail is the antithesis of detention, and things have moved on since those old cases. We don't seek to place greater reliance on it than that, but it is coincidentally one of those cases which falls into the group that demonstrates how the courts have seen the availability of bail in unlawful detention cases as a useful tool. And therefore, it is all of a piece with the line of immigration cases, starting with Bashir, that was cited.
Except, as Mr. Fordham points out, the finding was stayed.
Well, that is right. I accept that. And that's why I can't say it's binding authority for any part of the case that I put. But as an illustration of the same approach, we respectfully say that was a useful addition to the quiver. Learned friend Miss Harrison suggested that our case would involve, or that our case included a complaint about the effect if there was an immaterial public law error. Can I say, we do not complain about immaterial public law errors that don't undermine the lawfulness of detention. There's nothing between us on that, because if the lawfulness of the detention is not undermined, then there is no problem. The problem lies in material errors which do undermine the lawfulness of detention, and in particular the subset of those where the circumstances are such that the individual gets no false imprisonment damages because actually it's made no difference to him and he suffered no loss. Why, we ask, should it make all the difference between the existence and the non-existence of the bail power? That makes no sense. Can I then turn briefly to the points made by learned friend Mr. Fordham? He complains that on our case, a person could be released on bail even if they could never have been lawfully detained under the immigration powers. If there never was a detention power, there is no problem. We accept that the bail power couldn't arise. If the detention power has ceased, again, there is no problem, because we accept the bail power would fall away. That's the Qadir point, and everything ceases. And in respect of the people who should not be detained but have been detained, almost certainly because they are perceived to pose a risk of some kind, those are the people for whom bail is most useful. And we respectfully say that it would be an unfortunate consequence if the Act were construed so as to remove that possibility in those cases. Learned friend also says that there's no problem in there being a Hardy or Singh limit, which you have to look at all the time, because you always have to look at the Qadir limit. But we've already given the answer to that. The Qadir limit is easy to identify. The Hardy or Singh limit is very difficult to identify, and the case law demonstrates that. As a matter of history, I should say that the reason why Hardy or Singh, Tanti Lam and Mahmoud were habeas corpus applications only was probably, partly because judicial review had not developed, and judicial review in this field had not developed at that time, but also because the availability of bail in deportation cases only came in, I think, in 2003. It was one of the provisions of the 1999 Act, and you see the reference to that in the footnotes in the statute as printed. The case of I was a dual application, both judicial review and habeas corpus. And finally, learned friend made a number of points using examples of, with respect to extreme cases. For example, the Stellato case, the individual who just point blank refuses to comply, so that he can't be released on bail even though bail is on offer to him. We respectfully say that you can't construe a statute by reference only to such extreme cases. In any event, if somebody is behaving in an extreme way like that, the chances are that that behaviour is indicative of some form of risk which is relevant itself to the Hardy-Singh balance of factors. Somebody who is absolutely point-blank refusing to comply is likely to be somebody who is going to pose risk when released. And so if you look at how the system ought to work, and how the system would work in practice, these are not good examples to use to judge the practicability of them. In any event, there are other Hardy-Singh effects. For example, somebody appearing and being briefly detained to be re-bailed, being asked their bail. Again, Hardy-Singh would perfectly clearly permit that, like the brief detention for the tribunal to consider whether they should be re-released on bail, because this is all of the piece with that brief detention, for example, at the end of the period where somebody's about to be removed, even if it's been Hardy-Singh unlawful to detain them for a long period before that. Hardy-Singh permits brief periods of detention like that, and there's no novelty in that. And finally, the point learned friend Mr. Fordham makes about Article 5 are all predicated on an unspoken basis that once you reach the Hardy-Singh limit, that's it. But that, of course, is not the case. As we've demonstrated and I've just submitted, Hardy-Singh can permit later detention, even if it, at one particular time, says it would be unlawful. So that is the fallacy in that submission, and the fact that Article 5 is pretty much identical to Hardy-Singh doesn't pose any sort of obstacle to the construction which we urge the court to adopt. At the end of the day, as my Lord Hughes says, it's a choice between bail power continuing until the Hardy-Singh limit, with all the problems that that entails, or continuing until the Qadir limit, which is a practicable, workable way of doing this, which doesn't contravene any principles and is certainly not anathema to the law. And we respectfully invite the court so to hold. Unless I can assist any further, those are our submissions.
It appears not. Thank you very much, Mr. Tam. Thank you indeed. We're grateful to everybody for their submissions, both orally and in writing. We are, of course, as always, grateful to pro bono interveners in the public interest to do that. Thank you all very much indeed, and we shall go away and puzzle out what the answer is and let you know in the usual course of events. Court is now adjourned.